Hello, friends. I welcome you all to this 45th session of Law of Evidence. And today we are going to study section 114 of Indian Evidence Act. It is very important from the point of view of being a judge or being a advocate as well as for various examinations also. And the overview of it, or the question which can be framed from it, is that what are the various occasions in which presumptions can be taken under section 114? That is, what are the various circumstances where under section 114 presumptions can be taken? Now, to know it in simple words or acronym, what we have today framed is that of BHN. BHN. These consonants will be of our use while these vowels won't be. And as you can easily remember, I have put some pictures also. So now let us start and see what does this section says. So occasions on which presumptions can be taken under section 114 is BHN, as we have seen. BHN. Now, what is B? B is business. So, in a business, whether it can be a public or it can be private. So, common course of normally the way business are being held, presumption may. Please remember the presumption under section 114 is that of may, and it is certainly discretionary upon court, and it is rebuttable also. So, if a business is being conducted, whether that business be public or private, then and we can presume that it is in its common course. The common course of business is being followed. Then H, that is human conduct. That whatever is normal human conduct, not a psychologically ill person, but a psychologically normal person. In normal course, what would be his conduct? The court may presume that that was his conduct. And this N is natural events. So, whatever be the common course of natural event or the way naturally a thing happens, the court may presume that it would have had happened in that particular fashion. Now, we'll just study this section and see what it is. The court may presume, remember, we said it is may means that it is discretionary as well as it is rebuttable. The existence of any fact which it thinks likely to have happened, so which is most probably would have happened, with regard being to the common course of, so normal or the way a thing normally happens, common course of natural events, human conduct, and public and private business. So public and private business in relation to the facts of particular case. However, the facts of that particular case is also to be seen. Now, there are certain illustrations, and these illustrations are very important. The illustration says the court may presume. So, the court may presume what? First, that a man who is in possession of stolen goods soon after the theft is either the thief or received the goods knowing them to be stolen unless he can account for his possession. So, illustration A says that suppose this is a person and he has with him certain good which is stolen. Then, in case he can account for its possession, well and good. If we cannot account for his possession, the court may presume that either he is a thief who has actually taken the good or has received it knowing to be stolen. However, uh, there are three things which must be proved in such cases. Our prosecution has to establish three facts. First fact is that first fact is regarding the ownership of the article is in question. So, ownership of the article, that is, to whom this article belongs, should be in question. If it is proved that the article actually belongs to him, there is no way the court can presume that he is thief or he has actually received it. Second, then the theft of the article should be proved, that the article is or a theft has certainly occurred. And third is that possession has to be proved, that that person was in possession of this particular thing, and possession has to be conscious, it has to be exclusive and recent. But recent would be depending upon case to case. So even if it is 2 months, 3 months after, it can be taken to be a recent one. So this is what is section or illustration A of it, that person who is in possession of stolen goods soon after the theft is either the thief or has received the goods knowing them to be stolen unless he can account for his possession. Now, second is very important. Many a times it will be asked. We will read it further when we are discussing section 133, and in great detail we will read at that time, that an accomplice, that is partner in crime, is unworthy of credit unless he is corroborated in material particulars. So a person who has accompanied in crime or a partner in crime, so to what extent he can be believed? So certainly there will be a doubt on such person until unless there is a he can be corroborated in whatever he says. Some independent evidence must be provided in such cases. However, we will read it again and discuss it when we will be dealing section 133. Then C is that a bill of exchange accepted or endorsed was accepted or endorsed for good consideration. That if I have given anyone check, then certainly that I have received some consideration in lieu of that check. So this is something which we can presume. Else, how why will I give anyone any check? Then D says that a thing or a state of things which have been shown to be in existence within a period shorter than that within which such thing or states or things usually cease to exist is still in existence. So if it is shown that suppose there was a dog and normal life of dog lifespan is suppose 20 years, and if it is has been shown that before 5 years it has taken birth, then for the next 15 years the court may presume that it will remain in existence because it is a normal lifespan of the dogs. Then that judicial and official acts have been regularly performed. Now, this is important and we will discuss it in detail that judicial and official act have been regularly performed. See, whenever there is an act, on all the act, if question is raised, then it will be very difficult to carry out any proceeding. So there is a presumption, or a presumption can be made, the court made, that whatever was done judicially or suppose by police officer, it was done as per the procedure. Remember here that the presumption is about the procedure, it is not about the act itself. So we will presume that the procedure, through correctness of procedure, was there. Here, one case law is there, that is State of Bihar versus P. Sharma. Now, in this case, it was held that death in custody does not by itself create a presumption of murder by police. So, if there is a death in custody, so we cannot raise the presumption that the police has actually caused this death, because it will be presumed, the court may presume that he was properly taken care of. Then Sahnaj versus Dr. Vijay. Now, in this case, it was held that suppose there is a judicial divorce, and after a judicial divorce has been given, the wife claimed that the signature she gave on the paper was taken by force. So now the presumption will be raised that no, it cannot happen because the procedure adopted by the court was that of regularly performed. So the wife cannot be allowed to take this plea. However, it is rebuttable in nature. Please remember it. Next is F, that the common course of business has been followed in particular cases. So, whatever be the common course that was followed. Now, mostly it is used in case of letters, that is, delivery of letters. So, if a letter has been posted at a valid address, and so if there is a post is proof that the letter was posted on a valid address, and it is not returned back by the postal department, that is called dead letter office, then it will be presumed that the letter was received by the person to whom it is addressed. Where a letter is shown to have been posted and is not returned through dead letter office, the presumption is that it has been delivered. So that is F. Now G, that evidence which could be and is not produced would, if produced, be unfavorable to the person who withholds it. That is, if evidence is a person is called to give evidence, or a person has got a particular evidence and he does not give that evidence, then normal presumption would be that it is against him, therefore he is not giving that particular evidence. But there is certainly something which is important to be noted here, that in case of prosecution for an offense, it is not necessary for the prosecutor or for the prosecution to examine all witness. Suppose prosecution has named PW1, PW2, PW3 in charge sheet, and PW3 is not examined. PW1 is examined, PW2 is examined, but the prosecution case is fully established by their examination or by their evidence. Then presumption cannot be raised that PW3 was not examined, and therefore prosecution case has failed. In Rajendra Kumar versus State of UP, it was held that the court should not mechanically draw an adverse inference merely on the ground of non-examination of witness, even if witness is a material one. So non-examination will not give rise to the presumption. What will give rise to the presumption is that if he is asked to produce, and that is important for prosecution to prove his case, yet he does not produce it, then it can be presumed that he is not, or it may be in his against his interest. Then H, that if a man refuses to answer question which he is not compelled to answer by law, the answer, if given, would be unfavorable to him. So, if a person is asked a particular question in a judicial proceeding and he declines it to answer it, and it then it can be presumed that maybe the answer would be against his interest, and therefore he is not saying it. Then it says that when a document creating an obligation is in hand of obliger, the obligation has been discharged, but the court shall have regard to such fact as considering. Now there are certain more points in it, but thing is that if a document is in hand of a person who has executed that document, then it can be presumed that obligations which were therein he has particularly performed. Now, as far as marriage is concerned, so continuous, that whether two has the boy and a girl, they are husband or wife or not. So if there is a continuous cohabitation and their relative and friends, they take them that both as husband and wife, then it can be presumed that they are married. However, in case of Lolo versus Durghatya, it was held that suppose this is husband and she is wife, but she leaves her husband and she starts cohabiting with another man, and they give birth to a child also. Now, in that case, this child, it cannot be presumed that this W and M are husband and wife, because W is already wedded to husband, to H. So this is what is about section 114. Read it very carefully. Many a time questions are asked regarding it in prelims also, as well as in mains also. So various occasions in which presumptions can be taken is that the court may presume that common course was followed in business activities, human conduct, and natural events. However, there are certain um, things which are to be kept in mind regarding the particular cases, that how that particular case goes, and the various examples which we have seen. Thank you, friends.